Hello, everyone. I am AJ Weisler. I'm a labor and employment partner in Husch Blackwell's Food System Business Unit. For most of you, you probably know me best as the older brother of Husch Blackwell alumni and current webinar attendee Luke Weisler. But it's in my role as partner that I'm excited to welcome you today, and so many, Luke and other members of our alumni community. We hope you are enjoying, maybe right this moment, the fall alumni newsletter that was sent out last week. If so, or if you haven't had a chance to check it out yet, you'll find a link to it in the webinar console today. We're excited to keep sharing alumni updates from you and from others, and to you and to many others. So please do, if you have a new email that you prefer to use for your alumni communications, take the time to update that today. And do not hesitate to reach out to Stephanie Dorsum with any career milestones or other personal news to be shared with that HB Alumni Network. Before we begin the substance of today's webinar, I have to cover a few housekeeping items. So at the bottom of your audience console, you will see that there are multiple application icons for your use during the program. If you have any questions or comments during the webcast, please submit them via the question box. We will try our best to answer them either live or in writing during the webcast today. But if a fuller answer is needed, we may send you an email after the fact. All of the materials for the presentation are in the program materials folder. This program has been approved for legal education hours. So to report those hours, use the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you along with a recording of the webcast for you to watch over and over and over again. It really is an honor to have so many attorneys who used to practice law at Husch Blackwell joining us today. Speaking of people who used to practice law for Husch Blackwell, one of the speakers joining me today, and you'll hear from him shortly, is Joe Glinius, who is the current chair of the firm and also a labor and employment partner in the Food Systems Group. And rounding out our presentation today, we will hear from Scott Myers, who many of you may remember from your time working at Husch Blackwell when he was but a young associate. You'll be surprised to hear that he is now a partner in our group, which reflects, I think, the inexorable, continuation of time, and also the fact that social promotion is alive and well at Husch Blackwell. But you're going to hear from Scott. And we're going to be talking to you today about a number of very interesting topics within the labor and employment space, and specifically within wage and hour. So here is our agenda for today. So the first thing we're going to do is talk about the background for the types of cases and types of laws at issue when we talk about wage and hour. On the agenda, you'll see we're going to talk about the question, where can you get sued? For all of the non-litigators on the call who are thinking, don't they mean courtrooms? You're right, we do get sued in courts. But we're actually going to talk a little bit more about how complex that gets and the challenges that we have about jurisdiction and the types of areas where you or your companies may end up being sued and having to defend a lawsuit. We're going to talk about what to do after you are sued and what the next steps are and how best to present or position yourself to defend these wage and hour class or collective actions. Then we're going to talk about some pressing issues in today's business environment, some specific legal issues that are sort of on the forefront or kind of evolving. And we're going to talk a little bit about legal developments. That's where we get to put on our prognosticator hat and pretend like we know what's going to happen next. And if there's some time left at the end, I'm actually planning to use that so that Luke and I can have a discussion about gifts for our parents this holiday season coming up. So if any of you have any thoughts on what is an appropriate or great gift to give to a couple of 71-year-olds who have one son of whom they are proud and another of whom they are less proud, please do throw those into the chat. That'd be really helpful. But without further ado, we will jump into the substance of our presentation. And again, we'll start with the background of what these lawsuits are all about.
Thanks, AJ. Hi, everyone. For those of you that don't know me, I'm Scott Myers, and I am looking forward to talking to you all today about wage and hour. So wage and hour, again, a lot of you probably already know that, but especially for our non-litigators out there, kind of what we're really talking about. Wage and hour laws are everything with respect to compensation and hours, right? How much money employees are earning for how much they are working. And the federal law is the Fair Labor Standards Act. That's the one that pretty much every employer is going to be covered by. However, what makes this area can be particularly challenging is that every state can have their own wage and hour laws as well, and they are oftentimes much broader than the FLSA. For example, states like California and Kentucky have fairly strict meal period requirements and rest break requirements that hourly employees must receive, whereas the FLSA does not go as far as to talk about that. The FLSA sets a minimum wage, but state laws may have a higher minimum wage. And so this is one of the areas where not only are you having to comply with a federal law, but you're also having to comply with a state law. And then sometimes they can be different. And so it's an important to know basically all the jurisdictions in which you have employees and what the laws there are with respect to wage and hour. One other thing I wanted to point out, I started this by saying it is, about compensation and hours, but there's also a big part of this, and that's record keeping track of employees' hours and how much they're earning, and being able to have that readily available. Because if you ever are audited, or if you get involved in the litigation like we're going to talk about later, the most critical evidence in all of those situations is always your time and pay records. If any of you have ever been involved in class or collective action litigation for wage and hour, you have heard the request for time and pay records. So making sure you have a system that can accurately track that and maintain it is critically important to mitigating risk down the road. Okay. We're going to talk today in the context of litigation for wage and hour, right? There is plenty of focus that can be spent on stuff that is not in the context of a case, but that's what we are here to talk about today. And what makes wage and hour litigation particularly intriguing these days for plaintiffs' lawyers is the fact that they are very susceptible to class and collective actions, right? You can have a single plaintiff claim for sure, but they are generally of a lower value. However, these cases, unlike other employment cases, whereas you might have a discharge that affects a single employee, a single decision, and they're the only plaintiff. Here, it's typically involving policies or practices that are impacting a huge classification of employees, sometimes thousands of them nationwide. And so that case, the value of that case can inflate very quickly. And it's enticing for plaintiffs' lawyers to take those cases on because, as we all know, the fees are much higher in those class and collective actions than they are in single plaintiff cases. We're going to talk more about this later, but the difference really between collective action and class actions, collective actions are the claims when they are brought under the FLSA, that federal law. And those are going to require potential class members or collective members to opt in. If they don't affirmatively opt in, then they are not part of the collective. Whereas Rule 23 class actions for state law claims, those function like other types of class actions that are not necessarily employment related, where notice would go out after certification and then individuals have to opt out because they are already going to be affirmatively part of the class. So that's a distinction between the two. And again, we'll talk more about that as we move on throughout this presentation. Now, Joe's going to talk about how you can get sued.
I think that's me. Thanks, Scott. So as Scott mentioned, normally when we're talking to you guys about wage and hour issues, it's more about the substantive law, changes you should make, practices you should be aware of. Today's a little different because we're talking about these procedural elements of actually getting sued, which is odd, but it's because it really highlights some of the things that are the most important about defending these kinds of cases, which is who's your judge, what's your jurisdiction, what's the procedure you're stuck with. You have state laws that you have to deal with. You want to be sued, obviously, in a place with as few plaintiffs as possible, with a judge and a jurisdiction that's favorable to you, substantive law that's favorable to you. All that's very critical. And apologies to anyone who attended our most recent labor and employment seminar. We had a very similar presentation at that point. Although I'm suspecting that most of you who are doubling up knew that and either came just to hear some AJ humor or you weren't listening the first time. Either way, you're probably gonna be disappointed, mostly because AJ's humor is the same and our content's exactly the same. But anyway, let's do a little bit of a background on how these types of large class actions and collective actions get filed. Like anything, historically, someone can bring a lawsuit where they're injured. And so for your employees, if you're a multi-state employer, that means that they can file the lawsuit wherever it is that they're employed. And because you are conducting business there, you have the minimum contacts, all that stuff, you're subject to jurisdiction in that court. And so you could be stuck with defending, let's say you're a Missouri corporation, you could be defending a lawsuit in California, and that presents its own range of problems. That is still the case in the sense that an employee can sue you wherever he or she works. But there has been a trend recently that might limit whether people can sustain nationwide class actions based in the state where they work. So a little bit of background that doesn't come from the employment area. Apologies for the throat situation. It was a case involving Bristol-Myers Squibb. I'm sure many of you are familiar with it, from 2017. And in that case, the lawsuit was filed in California. As you know, Bristol-Myers Squibb is a large pharma company. And there was a consumer in California who claimed an injury from using their pharmaceuticals. So filed the lawsuit in California, which is not surprising. That's a very favorable place to file a lawsuit. And then sought to have a nationwide class that would include all of Bristol-Myers Squibb's customers, consumers from around the country. And just as another aside, this is something for those of you who may have worked in the St. Louis or the Kansas City or the Illinois offices for Husch Blackwell 15, 20 years ago. We saw a lot of this around the tobacco litigation. All these cases were getting filed in Madison County and St. Clair County, Illinois, because those were very favorable jurisdictions. And at the time, they resulted in some of the largest verdicts in the country in the history of our judicial system. So anyway, the same result was sought in this California litigation against Bristol-Myers Squibb, and it made it all the way up to the Supreme Court. Now, the key about this case is Bristol-Myers Squibb is not headquartered, doesn't have its principal place of business, it's not incorporated in the state of California. Bristol-Myers Squibb has its principal place of business in New York, and it's incorporated in Delaware. The reason that matters is because those are the two states under which Bristol-Myers Squibb is subject to general subject matter jurisdiction, or general jurisdiction, I should say. There are other ways to be subject to general jurisdiction, but they're not relevant for that case or for the bigger issue. So the court was considering whether it's appropriate for Bristol-Myers Squibb to be stuck with a nationwide class action in a state where it doesn't have its principal place of business, where it hasn't incorporated, basically hasn't set up its residency other than the fact that it does business there. So the court considered and ultimately determined that you can only be subject to a nationwide class in those states where you are subject to general jurisdiction. Again, here, that's going to be New York and Delaware for Bristol-Myers Squibb. That was a classic rule, different from the types of opt-in collective actions that exist under the FLSA that Scott was describing a few minutes ago. And they're different in many different respects. Some courts would tell you they're not class action or collective actions at all. They're just really a large joinder that exists in a sort of unique way under the Fair Labor Standards Act. But the key is these claims, these types of FLSA collective actions have taken off because the way most courts have approached this, and AJ is going to discuss this later in the presentation, the way most courts have approached this is they will send notice out to all of your employees on what's called a minimal showing and a lenient standard of the fact that they are similarly situated. That's basically the thin guidance that's been given. And so in most cases, what that means is plaintiffs would seek to send notice to all of your employees at the very early stages of the litigation, sometimes at the exact same time the litigation is filed. And you wouldn't have the protections that defendants have under Rule 23, where it takes a lot of money, time, expense, proof, to get certified under Rule 23. All of that is sort of out the window under the FLSA. So these cases were getting filed all over the place. So it's a fair question to say, does the logic from Bristol-Myers Squibb, which was authored under Rule 23, really apply to this different procedure that exists under the FLSA and the sending of notice for an opt-in collective action as opposed to an opt-out class action? As I mentioned, the Supreme Court didn't address that. And so, like a lot of other issues, it's being argued now at the lower courts, first starting at the district courts, making its way up to the federal courts of appeals. So right now, there are, as you know, 12, call it 13 federal courts of appeals. The 13th, the Federal Circuit wouldn't hear cases like this. But of those 12 other courts, 5 of the courts of appeals have considered and issued some kind of a ruling on this issue. 4 of the courts of appeals, so Third Circuit, Sixth Circuit, Eighth Circuit, and now the Seventh Circuit have all ruled saying that Bristol-Myers Squibb analysis does apply to the FLSA. And in order to sustain a nationwide class action, against a defendant under these FLSA claims, you've got to sue them in the state where they either have their principal place of business or they're incorporated or otherwise subject to general jurisdiction. But the First Circuit has actually gone the other way. As you know, the First Circuit is like Maine, Massachusetts, New Hampshire. And so if you are an employer, for example, in the state of Missouri and you are headquartered here, you have a principal place of business and you're incorporated here, but you have employees in Massachusetts, they could sue you in Massachusetts and sustain a nationwide collective action under the FLSA against you there. Whereas if, again, you're a Missouri company because you have your principal place of business and you're incorporated here, but you get sued in Illinois, you could make that case come to Missouri if they want to sustain a nationwide collective action. But of course, this is only some of the federal courts, not all of them. And there's a bit of a mosaic that multi-state employers have to manage at all times. So what we're left with in those other circuits that haven't ruled on it is some uncertainty. We're seeing more and more district courts weigh in, but until it gets to those circuit courts, obviously it's still going to be somewhat unresolved. And I think it's going to stay unresolved for a little while. So as you see on this slide, in 2023, the Supreme Court had an opportunity to address this circuit split that's been growing here for a while in the Third Circuit case, Fisher versus Federal Express, and it decided not to take it up. This is actually the third chance that the Supreme Court had to consider this to be a circuit split and try to resolve this issue and provide some clarity for all the federal courts and the litigants along the way. And so at this point, it feels pretty clear that the Supreme Court isn't going to take this up anytime soon, probably with a preference for just letting this play out and see what the district courts and the federal courts of appeal do with this issue. So what that means for us during this period of time is if you've got employees in jurisdictions where this issue hasn't been resolved and you could become subject to a nationwide class there, you really got to think about what steps you should be or could be taking right now to protect against major exposure. And this becomes particularly acute in states where they have really employee-friendly laws, or maybe the jury pools would be really employee-friendly, especially if those employee-friendly laws would be such that they could have a simultaneous Rule 23 class action and a FLSA collective action at the same time. And so if you're in one of those situations, so California, these days Colorado has become much more employee-friendly, this is the time to really think about what your exposure could be in those jurisdictions. Check your wage and hour practices, see if they're compliant with state law in addition to federal law. If not, make sure that they are, make the changes you need to make, because otherwise getting sued there in that friendly jurisdiction will subject you to a really hairy nationwide class and collective action. Now, there are some tactics that we can employ if you get sued in one of those jurisdictions and you don't have general jurisdiction there, but it's not very wise to rely on that for now. So this is a good opportunity to, again, think about what the impact of this procedural uncertainty is in many of the states across our country, and make sure that your wage and hour practices are compliant in those areas. So with all that said, I'm going to turn this over to Scott to talk about what you do once you've gotten sued.
All right. Thanks, Joe. After, Joe's just talking about all the different places that you could get sued, and now we're going to talk about what happens when that lawsuit finally comes through, right? So earlier I mentioned how the FLSA does the collective action process, conditional certification opt-ins versus the Rule 23 opt-outs. Joe was kind of hinting at it, and the standards used there. But really what that means is once a case gets certified, notice gets sent out. And in the FLSA, that's typically been happening very early on, and it can just really change the value of a case from that initial standpoint, even before discovery has been done. Any discovery's really been done. And that's been another driver to this surge in litigation that we've seen, is just the relative ease with getting these conditional certifications. However, finally, many courts have started to question this, and that's what we're going to really talk about going through these next slides. But the main approach has been what's known as the Lusardi approach. That was a case about 40 years ago now. It just came with a New Jersey district court case. And what they did was they developed this two-step process for conditional certification for collective action claims, it's known as conditional certification. And really, it's been widely adopted. Everyone used it. There was really no resistance against it, and it just kind of became the law of the land, despite it just being judicially crafted by a district court in New Jersey. So there's two stages to sending out notice under a collective action or having it certified. Stage one is known as conditional certification. That applies that lenient standard that Joe was talking about. It requires only a modest showing for plaintiffs to send these notices out. And now, to be clear, this modest showing is truly that. It's probably in any area of the law the lowest burden for something that can have such an impact on a case. It's hard to even think of something comparable. It's gotten so simple in these jurisdictions that are still using the Lusardi approach that oftentimes defendants will just stipulate to conditional certification. We've taken that approach. We've recommended that approach to clients several times before. Now, often you're able to do that because you're getting something in return. For example, we can offer to stipulate to conditional certification in exchange for them agreeing to a more narrow collective, right? Or maybe if they've sued about 20 different facilities that your client operates, we'll agree to stipulate conditional certification, but only the 2 facilities where the plaintiffs worked are going to be at issue. So you can use this as a way to, we're always looking for a way to leverage something that typically won't be in our favor, and that's that very lenient conditional certification standard. It's okay to stipulate to that because at the end of the day, it's probably just getting rubber stamped anyways. And so if you're able to get something out of it, you should definitely explore that. Okay, so let's talk about what happens once conditional certification is granted. Again, this is happening at the very beginning of a case. Sometimes plaintiffs will file a motion for conditional cert contemporaneously with the complaint. Once conditional cert's granted, there's usually between anywhere from like 60 to 120 days, depending on how the court orders the notice be drafted, where notice will get sent out to the putative class members, and then they've got 60, 120 days to return those opt-in forms. Once they opt in, they are then considered a party plaintiff. They will be subject to discovery. That can be kind of a point of contention. Some plaintiffs will want to limit those opt-ins participation requirements, but we always push to claim that they should be full participants. Anyways, the opt-in rate can vary, right? We've had cases where less than 5% of employees have opted in, and we've had cases where over 50% have opted in. It really just depends on the workforce, the types of claims, and sometimes how you are able to reach these folks, right? These days, it's very hard to object to electronic notice. In the past, it would just go out through the mail, and when email and text messaging weren't as common, nowadays, pretty much all these notices are going out through the mail, text messages, and emails, and sometimes it will also have to be posted in the workplace. But so that all happens at the very beginning of a case. And then once you get this putative class now, or once you have the actual opt-ins, only then do you start litigating, and step 2 would come in, which is where defendants would file for decertification. That decertification filing is typically happening at the same time in a Rule 23 case that certification would be sought. Right after that point, a record of evidence has been developed, and a court can actually make an educated and informed decision as to whether or not the case should actually move forward certified as a collective action. However, once you get to that point, people have opted in. It's I would say you are facing an uphill battle to get decertification, and you're having to expend a lot of money and discovery to get to that decertification point. And so what we have seen is that oftentimes it is wise to at least explore settlement at the very outset of a case, whether that's in an early mediation or there's other tactics. I'm actually going to have AJ talk about them because I know he's got some really interesting thoughts on different settlement strategies. But this is one of those where you really want to consider that early settlement, because at that point, before conditional certification, both sides still have that risk of what is that opt-in rate going to look like. Whereas if you wait too long and you get a good opt-in rate, you're really behind the 8 ball. So AJ, do you want to talk a little bit about some settlement strategies?
I do. Just to be clear, I told Scott I had thoughts. He added the really interesting part, so you all can decide if that was setting you up for a reasonable expectation of what's about to come. So when you're talking about settling these cases, a lot of it depends on kind of the particular flavor of case that you have. So whether you have an FLSA only, so a claim that is only bringing federal claims under these procedures that we're talking about under the FLSA, so meaning not a claim that deals with Rule 23 and the other standards, and we're going to talk about those, in some more detail. So just under the FLSA, or if you have one where both FLSA claims and state claims are being brought for the same population of people. So meaning, a claim that brings an FLSA claim on behalf of all of your employees in the state of Ohio, but then also brings a state claim for all of your employees in the state of Ohio. And then there are times where you have a national FLSA claim and then state-specific state claims, right? So the complexity of these cases can vary significantly from the outset of what they're trying to do. And it depends on which of those you have as to whether or not early settlement makes a lot of sense, or can be particularly advantageous. And the reason we tend to explore early settlement in an FLSA claim is that you will shock no one on this call to hear that the plaintiff's fees are what drive these cases all the way from the moment they're filed until they're resolved, right? It's the possibility of a plaintiff's fee award that they're focused on. And in a settlement, or in a, whether it's a judgment or settlement, the court is going to have to approve that fee award. And so mostly plaintiffs are focused on structuring and litigating and, positioning themselves to be able to be approved for a settlement value and a plaintiff's fee award that is enough for them, right? Whatever number they have in their mind for this case. So when you're trying to talk through or think through settlement, in an FLSA only case, again, there's no Rule 23 here. This is just this opt-in process. If you do it before you send out that notice, plaintiffs will like it because they get to use the overall settlement value for all of the claims in the case. Every potential opt-in is included. And so let's say it's 1,000 people, they get to use all 1,000 people and say, here are these putative collective members. Their claims are worth X. And defendant has agreed to pay some portion of X, and we want just a third of what plaintiffs have defendants have agreed to pay. That's perfectly reasonable. Court go out and approve that. From there, the process then plays out where we send out the notice, and once the court has approved it, and then we send out the notice, and everybody who opts in gets their check and participates. People who don't opt in don't get a check, don't participate, and that money either stays in our bank accounts or comes back to our bank accounts. And so plaintiffs are able to get a fee award approved on a larger number than the actual amount that we pay. It's very similar to like a claims made settlement that you may have dealt with in a non-employment world, because it's effectively what it is, right? So the attorney's fees are based on the overall value. If you settle an FLSA case after the opt-in process is done, so after the universe of people who are going to participate, you will typically end up paying per person more than you would if you settled it earlier. Because now when they go to the court for approval, the dollar amount that they can use is the actual value that we're going to be paying out, because this opt-in process is done. We know that of the 1,000 potential claimants, only 10% actually showed up. And so we're going to agree, and we know how much we're going to be paying for those 100, and they want a third of that, right? So it ends up being a third of just the value of 100 claims instead of the value of 1,000 claims. So because we're talking to you all and not filing something in court, we can use the dreaded word, which is collusion, and there is a fair amount of, maybe it's not collusion, maybe it's a coincidence of incentives, right, where we and the plaintiffs align on the value of the case being worth more to both of us early on, where we can agree to a bigger number because we know we won't pay out all of it. And so that is one reason that we will often engage in early settlement negotiations. So that's even before, as you're seeing this sort of process, that would be before stage one. So we've agreed and we settle it. In cases, and we won't get into all of these details because it gets too complex and the permutations are too many, but in cases where we have both FLSA and we have state claims, especially where they're the same population of people, this FLSA claim, the value of it is typically very small compared to the state claims that they're also bringing, because this opt-in process means fewer people join. they're able to proceed on behalf of fewer people. The opt-out process for Rule 23 that we'll get into in more detail, means you have a much larger population. And so this process is less about settlement, and it's more about them identifying people that will provide them evidence that they can use to support those state claims. So a lot of times there, it's not worth it to us or to them to try to resolve just the FLSA or to try to resolve things early on in the case. So there are some basic outlines of kind of when we strike, when the iron is hot in settlement negotiations, and why it might make sense, even in a case where you feel like you have good defenses, but before you have gone through these long and complicated steps, it might make sense to find out what kind of deal can you get from plaintiffs. And they tend to be pretty generous early on.
Thanks, AJ. Okay, we are going to get back to talking about this notice process, the conditional certification, and how it has evolved over the past couple of years. I started this by saying, look, like 40 years ago, we had that Lusardi approach developed, and it really didn't face much resistance until things started to change in 2021. And then the Fifth Circuit came out and just outright rejected Lusardi and introduced what's known as now the Swales approach. In Swales, really, the Fifth Circuit emphasized by saying the FLSA doesn't say anything about a two-step conditional certification process, right? This was completely judicially created. It's not mandated by the statute. And so is it really the best way to go about these, especially when, like AJ just said, you could have state law claims covering the same populations of people, really arguing over the same wages that are missing, being subject to a completely different type of certification process. So it just didn't make much sense for everyone to just assume that Lusardi was the law of the land and not question it. Well, when the Fifth Circuit considered all of that, it decided that courts should rigorously scrutinize whether employees are similarly situated before certifying a collective action and sending out notice. That rigorously scrutinize is the standard that they said makes more sense when it comes to determining if a case can proceed as a collective nature. In part because, again, as we've been talking about, once a case is certified, the value changes. It becomes a lot bigger deal for a defendant to handle than a single plaintiff case. So now the Swales was saying we need to have some discovery. We need to look at evidence. We need to really determine if these individuals are similarly situated before we are inviting people to join. This was a huge change. It really was. Because, again, I want to emphasize how much of a disadvantage this two-step process had historically been for defendants. And AJ just went through all those different strategies that we have to consider about these early settlements because we are stuck with this two-step rubber stamping conditional certification process. Well, the Fifth Circuit has come in and will hopefully change that for other jurisdictions moving forward. But again, it is just binding in the Fifth Circuit right now. But it certainly has influenced other circuits, and we're continuing to see that. The Sixth Circuit being the one that finally kind of took the plunge after the Fifth Circuit in questioning Lusardi. However, the Sixth Circuit kind of threw a wrench into all of this, and instead of it definitely said, look, we agree, Lusardi it's not required by the statute. There really doesn't seem to be a good justification for it. However, we also don't necessarily agree with the Fifth Circuit. We don't think that we need to just get rid of this two-step process and go to the one-step process like Rule 23 and like Swales is saying. Instead, we think that we should have a two-step process, but we're going to raise that modest showing standard. Instead, we are going to now require a strong likelihood that the named plaintiff or named plaintiffs are similarly situated to the collective they seek to represent. So what does that actually mean? Well, if you're a plaintiff, and you know that you have this strong likelihood requirement, you're less likely to seek conditional certification, step one certification at the outset, like you would under the Lusardi standard. So Clark, by saying you still have a two-step process, but you have this enhanced burden, they're effectively telling plaintiffs you should engage in some discovery before you seek conditional certification. Right? There is no requirement that conditional certification is sought at the very outset of a case. Plaintiffs have the option to engage in discovery and develop their evidence. They just typically haven't done that in the past because they don't want to do the work and they know they can get the conditional certification granted quickly. So Clark has now said, look, you can still do it immediately. We're still going to have this two-step process, but if you do it immediately and there is no record of evidence, you're going to have a tough time meeting that strong likelihood showing. So we expect to see some more discovery taken by plaintiffs in cases that are filed within the Sixth Circuit. And even though there's still that two-step approach, I think it's going to function a little more similarly to Swales than how Lusardi has been handled in the past. Okay, so to kind of put a bow on how conditional certification is being viewed, we really do think this is just the beginning, right? The Fifth Circuit and Sixth Circuit in just the past couple of years, and Swales and Clark have already come out and have said, we're leading something new. The Seventh Circuit, just a few weeks ago, has said, we're going to revisit this as well. So that case is coming up, hasn't been heard yet. But now the Seventh Circuit's on board. No other circuits have indicated that they're taking the cases yet, but I'm surprised if that happens. And in fact, this is probably also eventually going to make it to the Supreme Court. We just expect the Supreme Court will want some other circuits to weigh in, other than the two right now and then the one that's coming down the line. Usually they want to see a majority of the circuits before they're going to really address a circuit split. So what does this mean for everyone here? Okay, well, if you're in a jurisdiction that's outside of the Fifth and Sixth, and then Seventh to be determined, you are still bound by the Lusardi approach. However, maybe now is the time, if you are facing a conditional certification motion, to respond arguing against the Lusardi approach and suggesting either the Swales or Clark approach, and encouraging the district court to abandon Lusardi and go with what these appellate courts have considered to be the correct way to do this. Obviously, you would still want to then argue alternatively under Lusardi, but you should be putting this before courts, because maybe that's the case that ultimately gets up to the Court of Appeals and changes the law in your jurisdiction. We are defending a case within the 11th Circuit where the district court actually came out and asked for additional briefing on this standard. So district courts are certainly listening, right? They are in tune with what's going on. I would be surprised if any district court came out these days and just said, absolutely, they think Lusardi is the best way to go in and refuse to question it, right? Maybe they might not give much thought and until a circuit court comes in and tells them to change. But it seems like district courts are being more receptive to this idea that maybe Lusardi is kind of a thing in the past and we should reconsider. So I'm now going to turn, that's kind of our talk about what happens when you're getting sued and where you can get sued. Now I'm going to send it back to AJ. He's going to talk about one of the issues that we are seeing pop up a lot in lawsuits these days.
Yes. So within all of that complex procedural space, we deal with actual substantive claims, right? And so one we want to highlight today is one that is getting a lot of attention. Traditionally has been very common in states like California, where it was early on sort of identified as a problem, but that has expanded. So we're talking, of course, about rounding. Rounding in this case, and we'll get into some details of what we mean, refers to the practice of altering an employee's time records, so their time punches or their time entries, in a systematic way. So up, down, depending on what the minute was. As lawyers who have worked at a large firm, similar to the idea of us, deciding our value in our lives by 0.1 of an hour, rounding is that same idea, but applying it to an hourly workforce. And it remains and is a growing claim, common claim. And it tends not to be in jurisdictions outside of California, tends not to be a claim that has a whole lot of inherent value, meaning like if you run through it, you're going to find huge dollar amounts. Sometimes there are, but it's also a claim that goes through that certification process that we just described most of the time. So it's hard for us in a rounding case to defeat, especially conditional certification, because they really just have to say that there's a common policy of rounding and it applied the same way to groups of employees, and courts will conditionally certify that. We can get into the merits of that in some cases, and obviously the farther we get away from Lusardi and into these more rigorous tests, the better chance we'll have. And so rounding is a claim that will tend to get certified. It includes Rule 23 certification in a lot of areas, depending on the state laws and the state procedures particularly. But then we also have the challenge that rounding is effectively a gateway claim in this space. Gateway, not like the arch, but gateway more like a drug, meaning it gets a plaintiff a hook into the litigation, allows them to get searching discovery of our records, our time records, our pay records, our policies, and they use that right in federal court and elsewhere to see if they can find other problems that maybe they don't know about that they can then proceed on. So it's a claim where it gets a lot of focus because it is kind of the low hanging fruit on certification and because it's getting attention from the courts. So rounding is widely used. It has been used by employers since the advent of electronic timekeeping systems, and it existed before electronic timekeeping systems. And so now we find ourselves in the 21st century, and we have courts who are taking this widely viewed practice, and they are starting to narrow it and what we're able to do with it. And that includes employer-friendly circuits. So here's an example. What does rounding look like? So an employee clocks in. So maybe they use their thumb on a biometric clock, or they enter a key, or they use their phone to hit start on their day. However they clock in, it's recorded as 8:03 a.m., but the system automatically rounds it to 8 a.m. And then the employee clocks out at 4:58 p.m., and the system in the background automatically rounds it to 5 p.m. There are a million options for how to do these things. Something that is fun for us, maybe not so much fun as it is interesting and sometimes entertaining, is to find out the disconnect between how companies think that their time is rounded versus how their time is actually rounded. So most employers, unless they have gone through litigation like this, have some kind of rounding in place. And their employees and their supervisors, their managers will generally know that it's a 5-minute or a 10-minute or a 15-minute round, meaning that it goes to the nearest 5 minutes or 10 minutes or 15-minute increments. And the courts have, regulations of the courts have said, up to 15 minutes is typically or can be okay. But once you actually get into their records and you look into the details of it, a lot of times what's happening in their records does not match what they think the round really is. A lot of times they'll say, oh, it's just a straight 10-minute round, up or down, it just doesn't matter. And then you start looking at it and you try to apply that rule to the records you see, and it doesn't line up with what's actually happening. And you find out that in fact theirs is a round that's weighted back to the scheduled start, or they have a grace period, meaning everybody who clocks in before their shift for a period of time gets that time automatically rounded off. We're not that far removed from clients using lengthy grace periods because they had employees who wanted to show up, clock in, and then hang out talking to their friends. Unlike most of us, a lot of employees do make good friends at the places they work. As Husch Blackwell alumni, that's not really the culture here. But other places they do, they want to get there early, they clock in really early, and they hang out. We've had clients who had grace periods of up to 2 hours, meaning they would let someone clock in 2 hours before their scheduled shift, and then that whole 2-hour window would get deleted automatically by the system. So that is kind of the common practice, or I should say that's an example of the practice, and it is common. And the FLSA says that technically it's allowed as long as it averages out over time. And these are regulations, these are interpretive regulations of the rules saying by the DOL that rounding is okay. Joe's going to talk to you about what should happen if you go back to your people and say, do we round and should we round?
Yeah, and that first part of AJ's question, the do we round, is very prevalent. I mean, so a lot of you will be contracting with very large time clock and payroll companies. It is still shocking to me after 20 plus years of doing this that most of the time that information is not shared by your time clock company. That they are in fact rounding, and it's not really explained as to what the risks are and all that stuff. So that's something to keep your eye on. The next question that AJ mentioned about being sure why. There are good reasons to round. And as an aside, I think I'm the one talking to you about this because I'm the oldest and most weathered and beaten up by this over time of the three of us. There are good reasons to round. The one that comes most to mind for me now, today, is it does allow the potential for some greater reliability as to what your labor spend is going to be if you have pretty good structure around when employees start and when employees stop. their shifts and you have pretty good processes in place to make sure that they're faithful to it, and you're not needing a lot of overtime from your non-exempt employees, you can be able to really have some consistency in their hours worked, call it from 8 to 5, 9 to 5, whatever it is. And instead of having 7:56, 7:57, 5:03, you can know for a fact that you're going to get those exact number of hours. And if that's a big thing for your company, to have that reliability and that consistency on the spend, then that's a valuable reason to round. But as AJ mentioned, in today's technological world, it's not typically a meaningful explanation to a court to say that's the only way we could capture time, because we've got all these electronic time clocks. We can get right down to the minute. That's pretty much the way all time is entered in most businesses now. So the practicality piece of it is not nearly as persuasive as it once was. And so what we're left with is an explanation that I've gotten from a number of clients before, and it cannot be your explanation, which is we want to round to save money. It may be absolutely right that someone who comes in for a 9 o'clock shift and clocks in at 8:42 is doing nothing for those 18 minutes. And it may, in that sense, be totally appropriate to round that time off because you don't want to pay for it. But the problem is when that employee files a lawsuit for whatever reason, and we're asked the question as to why did we have our rounding policy? So we weren't paying people for all that time they were on the clock. It makes it much more challenging and much more critical that we can really prove that each one of those employees was not actually engaged in work for those 18 minutes. And so it can't be a reason to pay less. In fact, even in the courts that will allow rounding and bless the defense, most of the time they will require some examination, and this is coming from the regs itself, showing that over time, employees aren't cheated out of time. They aren't cheated out of minutes. It's got to average out in a way that it balances out and all the money gets paid. And let's be real. That probably means you're going to want to err on the side of overpay. So rounding actually becomes, in many instances, a more expensive way about paying for hours worked than paying to the minute would be. What it really highlights is the need to have good policies and procedures and structures around the way people clock in and clock out. AJ, I think you're bringing it home. Is that right?
I am. And as a member of the link, I work from home. So that's something I'm particularly good at.
Well done.
Yeah, thank you. So, this concept, as Joe was saying, is sort of how do we, if we still round, how do we do that? This balance in rounding to make sure that the plus and minuses over time balance out is crucial, right? Checking it to make sure that actually happens is crucial. Telling employees how rounding works so that they aren't later surprised by the fact that they are getting paid less money than the time on their time clock is important, right? Because these claims, these lawsuits don't just happen. They happen because some employee told somebody else, typically a plaintiff's attorney, about something that happened to them at their work, or they ask a question, and then that drives these litigation, and sometimes even a simple question about, hey, my employer pays me for less time than the time clock, and they were surprised by it. That complaint doesn't come to you; it goes to the plaintiff's attorney, and then they dig in deeper to your practices, and you get a much broader lawsuit from that employee. And then ultimately, after doing all of these steps and kind of continuing to review it, you may want to adjust your practices, your policies. And it's not just your rounding policy that impacts all of this, right? It's also your policies on how your employees arrive to work, where time clocks are located, the sequence of events at the beginning and end of the day. Are they engaging in work activities immediately upon touching the clock and immediately after clocking out, or immediately before clocking out? Do you have attendance policies that affect your allegedly neutral rounding, where you're forcing everybody to actually clock into windows that get rounded off in your favor? These are the sorts of broader picture items that you need to look at when you're trying to decide if your current rounding practice is one that is defensible, and then if you are needing to make changes, how do you do that in a way that is going to reduce the risk, maximize compliance? I mentioned before that this is, under federal law, it's been blessed. Most states have said rounding is okay as well, or at least neutral rounding is. I practice a whole lot in the state of California, and California even has never said anything from the California Supreme Court. That issue is currently before the California Supreme Court. But the California Intermediate Court of Appeals many years ago in a case called Seas Candies, referencing to the candy that you've sometimes purchased in airports, but I'm not sure is available anywhere else. That employer had a rounding policy, and the court said as long as it is neutral in the way it's created and neutral in how it actually affects employees, that's okay. And they blessed grace periods as well, as long as they were sort of an appropriate grace period policy that told employees, hey, you can clock in early, but do not work until you are on the shift, your scheduled start, and then it's sort of policed and enforced appropriately. Then, this is about 10 years ago, in the last year or two, the California Court of Appeals has started to move away from Seas Candy and question it, saying that the California Supreme Court in other non-rounding cases have said that what you really need to do is pay everybody for every minute that they work, and rounding doesn't always do that. And they particularly looked at rounding because we look at it in the aggregate, right? Not just rounding per person, but rounding across our entire population of employees. And so when we say rounding is neutral, what we mean is that these 100 employees either don't lose time or gain time as a group. And in California, they said, our laws are not laws that have to be complied with as a group, right? Your policy needs to make sure that each individual employee is paid for the time that they work. So you can't have a policy where you underpay employee A, but you justify it by overpaying employee B. And so there's a lot of criticism and expectation in California that rounding is going to go away completely. California also got rid of the de minimis rule, which is one that we use to defend rounding cases where we're talking about very small amounts of time that would otherwise be hard to capture. And the way they got rid of that is exactly what Joe said earlier. This idea of electronic timekeeping in 2024 means, do you really need to round? Like, is that something that's actually happening in your workplaces as a necessity, or is it something you're doing out of either inertia from what you've always done, or because you are in fact trying to reduce the amounts that you pay through a rounding policy? And just all of this side note, because in the case that focused in California on getting rid of de minimis and on electronic timekeeping, it was the California Supreme Court, and there was a concurrence. So in case any of you are thinking the obvious compliance option here is to implant electronic chips into each of your employees that automatically start and stop the clock when they arrive at certain places within your workplace. The California Supreme Court, in a concurrence, did say we would prefer you not use our opinion to justify implanting electronic chips into your employees. They viewed that as maybe a step too far, but we may not be that far off, from a future where that's how we live and that's how we calculate time, and maybe that's where we're headed in California and elsewhere. Probably not for a little while. But the next slide is where we get to talk about where things are going, right? So the future. So in addition to, the rise of AI and its impact on work and hours, in addition to, the increasing complexity or focus on rounding and the complexity of how we go about certifying these cases or defending certification of these cases, there are a few things that are on sort of the semi-immediate horizon that are worth talking about. So one of them is the change in the FLSA salary threshold for exemptions. So this is the law that allows us, to not pay overtime to all employees. So if I got a note that maybe I'm freezing, I'm gonna wait a second. Okay, now we're back. So this is the law that allows us to not pay overtime and minimum wage to certain employees based on the job they do and the amount of money that we pay them. And so it has to be a certain salary. So that threshold went up once already this year under a rule that was issued by the Biden administration. It is scheduled to go up again on January 1st. And then it is scheduled to automatically update every 3 years after that. That rule has been challenged in numerous places. Every time the salary threshold is increased by any administration, it gets challenged. For those of you who were either in-house already or working in the labor and employment space during the Obama administration knows that that rule was supposed to take effect, the Obama administration's, and was blocked by a district court in Texas and then ultimately abandoned by the Trump administration. The Trump administration's rule was challenged by a district court in Texas, and the Fifth Circuit recently upheld the Trump administration's rule saying that a salary threshold was allowable and that they had not exceeded their authority in using one. And now we have challenges to the January 1st threshold that are being heard in courts all over the country, primarily in a district court in the DC Circuit. And so we expect a ruling from those courts at some point between now and the end of the year about the viability of that January 1st challenge, understanding that depending on which administration is in place, after January 20th of next year, that rule will either be defended or abandoned, no matter where it is in the process. As far as the election-related issues that are coming up, so one of them is whether that salary threshold will continue to be defended. There are many others. So over the Trump administration, well, Obama to Trump to Biden, we have yo-yoed back and forth on how strict a test there is for independent contractors. Under the new administrations coming, there's an expectation that we will either continue to make it harder to use independent contractors, or meaning that there fewer people will qualify and more will have to be treated as employees, or we're going to see a test that loosens it up and goes back to the Trump era test, which is much broader and allows a lot more use of independent contractors. It gets away from some of the more strict standards that we see in states like California that really just look through all of it to try to decide if somebody truly independent, economically independent. Instead looks at the amount of control and looks at factors that are more employer friendly there. There's similarly an expectation that the joint employer classification will be loosened under a Trump administration or tightened under a Harris administration. The expectation or the reality there for wage and hour cases is significant, because if you're a company that is diversified in what you do and have a large parent company or holding company, their ability to kind of bring an employee who was only ever employed by one branch of your company will use that joint employment status to try to bring in other corporate entities within your umbrella and try to expand cases significantly, or at least threaten to do so for settlement leverage. And then finally, the overtime rules. So there's an expectation that there could be fairly significant changes under either administration, either increasing the availability of overtime and increasing the cost of that overtime, or several ideas put forth by both the potential Trump administration and by Project 2025 that talk about overtime are things that focus on taking the concept of flexible time off, which exists for public sector employers, and bringing it into the private sector. So meaning allowing employees who have earned overtime to use that as time off in the future, rather than having to pay any more money to them for the work they've already performed. There's also a proposal to change how overtime is calculated and take it from a weekly assessment to an assessment that goes over a period of time set by the employer. So instead of limiting you to 40 hours per week, they could limit you to 80 hours per 2 weeks, or 160 hours over 4 weeks, meaning you could take somebody who's worked a lot early in the session and reduce the amount of time they work later, and then avoid having to pay that overtime. So there are a number of changes that could happen, many of which are doable through simple executive order or through notice and comment rulemaking. Others, like changing the work week threshold, would have to be done by legislation. So we have, at the end of this session, I don't know how clear it's being picked up by my microphone, but my dogs are alerting me. I set the timer on them to bark at 1:58, and so they are. So I want to say a very sincere thank you to everyone for joining us today, for being part of Husch Blackwell's history as valued alumni and our future as continued valued webinar attendees. We hope the information that was provided today was helpful to you and to your organization. A few reminders. One, remember this has been approved for legal education hours, so make sure you click that icon and report it so that you'll get your certificate. And you will get an email with the course number along with the link to the recording in case you want to watch it again and again, or share it with others in your organization. Be sure to complete our short survey that you'll see linked there. We use that feedback to help plan future programs and choose gifts for our shared parents. And with that, I will say officially this concludes our webinar. Thank you.